All right, today we're going to dive into something pretty powerful and honestly, a little controversial. It's a legal tool that people call a financial fortress, the Domestic Asset Protection Trust, or DAPT for short. Now, it's supposed to be this ironclad shield for your wealth, but the real question is, how strong is that shield really? I mean, think about it. We live in a society where one lawsuit, right? It could be from a business deal gone wrong, a car accident, or even a messy divorce. And just like that, everything you've worked for could be at risk. That fear, that what if, is a huge driver behind the search for ways to protect what's yours. And that's exactly where this whole story kicks off. So in response to that fear, the legal world came up with a solution. You can think of it as building a kind of financial fortress. And that fortress has a name, the Domestic Asset Protection Trust. It's a legal structure specifically engineered to build a wall around your assets, to shield them from future claims. Okay, so what is this thing exactly? Well, first off, a DAPT is what's called an irrevocable trust. That just means once you set it up, you can't just, change your mind and tear it down easily. But here's the real kicker, the part that makes it so different. It's self-settled. That's a fancy way of saying the person who creates the trust can also be a beneficiary who gets money out of it. Now, with most old school trusts, that's a big no-no. But for a DAPT, that's its secret sauce. That's where all the power comes from. This whole concept is actually pretty new in the grand scheme of law. The story really starts back in 1997. Alaska basically looked around, saw a bunch of wealthy people sending their money to offshore trusts in places like the Cayman Islands, and had a light bulb moment. They thought, hey, why can't we do that right here in the US? And boom, the DAPT was born. After that, the idea just caught fire. By 2007, you had states like Tennessee jumping in with their own versions, and now it's grown to 20 states. Just let that sink in. 20 states. We're talking about almost half the country. So yeah, this is no longer some obscure niche legal idea. It's gone totally mainstream. It's a huge competitive part of the financial world, with states basically fighting each other to attract this kind of business. All right, so if you're going to build one of these financial fortresses, what are the blueprints? What are the non-negotiables? Let's get into the nuts and bolts, the key components you absolutely have to make a DAPT work. You can really think of it like building a house. There are 4 cornerstones you gotta have. First, like we said, it has to be irrevocable. The foundation is permanent. Second, and this one is super important, you have to appoint an independent trustee who actually lives in the DAPT state to manage everything. You can't be the one guarding the vault. Third, it needs something called a spend-thrift provision. This is basically a legal force field that helps block creditors. And finally, number 4, you have to actually transfer your assets into the trust. It's not enough to just say you did, the ownership has to legally change. Okay, and this is where it gets really competitive between the states. They all have what's called a look-back period. Think of it as a waiting period. It's the window of time after you move your assets that a creditor can still come in and challenge the transfer. And this is a huge selling point. You see a state like Tennessee offering just an 18-month period? That's incredibly attractive, because once that clock runs out, the walls of your fortress are considered seasoned. They're way harder for anyone to knock down. But then you have Nevada. Nevada decided to take this competition to a whole other level. See, most states have what are called exception creditors, think claims for alimony or child support, which can often get through the trust's defenses. While Nevada's law says, nope, no exceptions. Once their 2-year look-back period is over, the protection is supposed to be absolute. We're talking against any and every type of creditor. It's a pretty bold move. Okay, but here's the big but. This all sounds great, right? An impenetrable fortress. Well, not so fast, because this fortress has cracks in its walls, big ones. There are some major legal challenges and real-world court cases that show these trusts are not always the ironclad solution they're made out to be. And this is where it gets really interesting. The 2 biggest threats actually come from the U.S. Constitution itself. First, you've got the full faith and credit clause. Basically, this says that states have to respect each other's court judgments. So if someone gets a judgment against you in, say, California, a non-DAPT state, they might be able to force a DAPT state like Nevada to honor it. Poof, there goes the protection. And then there's the Supremacy Clause. This one's simple. Federal law trumps state law. So in a situation like a federal bankruptcy case, the bankruptcy court can just ignore the state's DAPT law completely. And even if you get past the federal issues, the shield still has holes at the state level. Remember those exception creditors we talked about? Well, most states have them. You generally can't use a DAPT to dodge paying things like child support or alimony. And let's be crystal clear about this last one. Using a DAPT to hide money from people you already owe, That's not asset protection. That's fraud, and it's illegal. And that brings us to the single biggest, most explosive area of controversy, using these things in a divorce. Just listen to this. This is a direct quote from a law firm's guide on the topic. Your client should set up this type of trust prior to filing for divorce and before it is obvious that the relationship is headed to divorce. Whoa. I mean, that's pretty blatant, right? This is where that line between legitimate asset protection and what feels more like asset hiding gets incredibly blurry. And look, this isn't just some hypothetical debate. It's played out in court. In a really important case, Dahl versus Dahl, the Utah Supreme Court had to deal with this exact scenario. Now, they ended up deciding the case on a different technicality, but they used the opportunity to send a massive warning shot. They basically said, hey, legislature, if you let one spouse just secretly move marital property into a DAPT, you're creating a serious conflict with a fundamental principle of divorce law, which is that assets should be divided fairly. So how have the states dealt with this? Well, it's a total mess, honestly. A complete patchwork of different rules. You've got some states, like Alaska, on one end, which have laws that explicitly protect spouses. Then you have others where the protections are kind of murky or weak. And then you have a bunch of states that say nothing at all about it in their laws, which leaves it as this huge, risky, unanswered legal question. It really depends on where you are. So, after all that, where do we land? What's the final verdict on these things? Let's boil this whole complicated topic down to the most important takeaways, because it's pretty clear this isn't a simple tool. Okay, here's the bottom line. Yes, a DAPT can be a powerful tool, but it is not a magic shield. Let's be real, its protections are nowhere near absolute. They've got serious constitutional challenges and all those exceptions we talked about. The level of protection you actually get can change dramatically depending on which state you're in, especially when it comes to divorce. And probably the most important thing to remember, this is for future unknown risks. It is not a tool for hiding assets from people you already owe money to. That's illegal. And finally, this is not a DIY weekend project. It requires serious, sophisticated planning with expert legal and financial advisors. And that really leaves us with the big central question here, doesn't it? It's a balancing act. On the one hand, everyone wants to protect what they've worked so hard to build. But on the other hand, where do we draw the line? At what point does smart asset protection turn into just dodging your legitimate responsibilities? The whole ongoing story of these domestic asset protection trusts shows that even now, the law is still grappling with that very question.